Thank you, Annette and Lisa, for the invitation. Good afternoon. I am acutely aware I am all that stands between you and lunch and that you have been very patiently sitting here for the last 90 minutes. So what I would like to do in the next 20 minutes, and then whatever questions we've got, is to give you some information about an aspect of disciplinary affairs so that you can go back to your clubs and associations to check out how your club or association is, and also to give you some information that what on the face of it appears to be an approach within sport law jurisprudence that protects athletes, when in my humble opinion is analysed properly, actually does not provide the safeguards that people thought it was going to do. So this morning we've heard all of the really positive things that can happen about sport, how communities get engaged, how at-risk youth is energised and perhaps saved. The reality is that within any sporting organisation there is going to be a need for disciplinary procedures. So there's the issue. You're going to have some sort of disciplinary structure to deal with what athletes do on or off the field, perhaps what spectators do, or what members do. So, you know, members might have a blue with their association, or members might have a blue with each other. The athlete commits an indiscretion on the field and clocks someone, or in the sport that I do a lot of disciplinary work with, cricket, engages in dissent. You're going to have to deal with them, or something that happens off the field. So that's the issue. That means that you're going to have to determine whether something has been proved or not. It means you're going to have a structure. Who's going to hear it? What are the rules? What evidence is admissible? Are they allowed to have lawyers? And one of the things you're going to have to work out is what's the appropriate standard of proof. Someone's going to make the allegation. What's the appropriate standard to work out whether that's been proved or not? This concept of comfortable satisfaction has been created in the last few decades. All international elite sport has signed up to it. So what I want to tell you about very briefly, what it is, where did it come from, how is it different to the two standards that those of us operating in the common law world know, the balance of probabilities and beyond reasonable doubt, and why is there a problem? This is where it comes from. There were some cases before the WADA Code, World Anti-Doping Authority Code, but it's now enshrined in this. So the standard of proof is something called comfortable satisfaction, and the last sentence, which is been emphasised, is the important one. So it is by definition, you've got the balance of probability here, it is by definition greater than that, and you've got beyond reasonable doubt here, it is by definition less. So it fits within those two things that common law lawyers are familiar with. So it's a sliding scale, and the information that I want to share with you today is that this carries risks for athletes and administrators because there are unintended consequences and potential injustices. For those of you who aren't familiar with the anti-doping global history, this is the 30-year summary in 25 seconds. So before WADA, the International Olympic Committee had its own anti-doping code. The committee, the International Olympic Committee, gets together a conference. WADA is established under Swiss law. There's a Copenhagen Convention. And I'll just go back. I think it still is the fastest piece of treaty work ever gone through the United Nations. So there was this huge global outcry about doping, and WADA is established and the WADA code is established. The reason that it affects us here in little old Australia is that the International Olympic Committee says that if you want to come and play in the Olympics, you have to sign up for WADA. So all Olympic sports throughout the world, so all of the Australian sports that participate in the Olympics have to sign up. And because it's a good thing to be seen to be anti-doping, governments say to national sports who are not Olympic sports, if you want our money, you need to sign up. That's why cricket, Aussie rules and other sports. So they're the national sporting organisations, and as you know, it's a hierarchical structure. You have your national sporting organisation, your state sporting organisations, then you filter down to the local competition, and then down to Parklands competition. And everyone is committed to this. So you go off to the Parklands to play cricket, you agree to be bound by the rules, they're part of the South Australian Cricket Association, they're part of Cricket Australia, they're part of the ICC. So that's why almost all of Sporting Australia is bound by this stuff. You'll see at the bottom of this slide a reference to attachment A. At the back of these slides there are a series of slides with extracts from cases. So this is simply a slide to say that before the WADA code came, there were 3 important decisions in the Court of Arbitration for Sport, which is basically the Supreme Court for sport around the place. It's established by the IOC in 1983. It operates out of Switzerland, and it is essentially an arbitration process. And it was talking about comfortable satisfaction, and that has now been enshrined in the WADA code. And we know that at Australian common law, that's what we're dealing with, beyond reasonable doubt and on the balance of probabilities. That's the weightiest bit of law that I'm going to ask you to read. The important stuff is in the first 2 lines. There is no third standard of persuasion, and the other important bit is that emphasised about two-thirds of the way through. The seriousness of an allegation made, the inherent unlikelihood of an occurrence of a given description, or the gravity of the consequences flowing from a particular finding, according to the High Court, and in the decades since, that's what you take into account. So this case, Briginshaw, is not setting something called the Briginshaw standard. Australia still has only 2 standards, the balance of probabilities and beyond reasonable doubt. But what Briginshaw is saying is that when you come to work out something in the civil context, you have regard to this. For example, a proprietor's shop burns down, the insurance company refuses to pay out because they say it was an arson job. Very serious allegation. That has to be determined on the balance of probabilities, but you have regard to the seriousness of the allegation, the unlikelihood of it. Most people who own shops don't go around burning them down. And that becomes a little bit important in a sporting context. For example, in the work that I do in cricket disciplinary matters, you have a run-of-the-mill garden variety descent. Person is given out, lingers too long, looks at the edge of the bat, I hit it sort of thing, and engages in dissent, might say something. You might, well you would, approach that differently if the allegation was that the bowler in the follow-through deliberately ran into the batsman as the batsman was setting off for the run, and essentially it's an allegation of assault. So the code, the cricket code that you're working with, might provide standard of proof is on the balance of probabilities, but you're essentially being asked to make a finding that this bowler deliberately assaulted a batsman by running into him or her as they set off down the pitch. So that's Briginshaw. It's not a separate standard, it's a process of reasoning, and comfortable satisfaction is not the same as beyond reasonable doubt. You'll remember back to the WADA code, it is expressly defined as greater than the balance and less than beyond reasonable doubt. And attachment B have a number of extracts from the leading Australian criminal cases that say the notion of comfortable satisfaction is not what beyond reasonable doubt is. The cases say beyond reasonable doubt are simple words. You tell the jury the standard is beyond reasonable doubt. You don't try and explain it. You don't tell them that they ought to be satisfied or comfortably satisfied or have no real doubt. So within Australian jurisprudence, it's absolutely clear comfortable satisfaction is not beyond reasonable doubt, and that's how it's defined in the WADA code. So, well, what's the problem? Well, the problem is it's a sliding scale. That concept is completely foreign to the Australian lawyers in this room, or lawyers from any common law jurisdiction. And the concern I have is the third bullet point there is that an athlete, on the face of it, is protected by this notion of comfortable satisfaction, because read the definition in the code. It is more than a mere balance of probability, but less than beyond reasonable doubt. So the more serious the allegation against the athlete, the higher the standard of proof. That's the thinking behind the code. But it is expressly defined as less than beyond reasonable doubt. And I think, somewhat ironically, it actually provides the athlete with fewer safeguards. These are the safeguards that exist when you are dealing with beyond reasonable doubt. If you were sitting on a jury in a criminal trial, you would be told that if you do not know where the truth lies, the person is acquitted. You would be told that just because you do not believe the evidence of the accused, that does not mean the charge has been proved. You would be told that if the account given by the accused is a reasonable possibility, they must be acquitted. You would be told that if there is an hypothesis consistent with innocence, they must be acquitted. And importantly, you would be told that if you are dealing with the larceny of a chocolate bar or murder, the concept of beyond reasonable doubt is exactly the same, which is completely foreign to what the WADA code says. You'll remember the WADA code says it slides. The more serious the allegation, but you never get to beyond reasonable doubt, which means you never get to any of these protections that are on that screen. And I think that's a problem for athletes. How do you apply it? The world leaders in a sport, the world leaders in cricket, who earn their livelihood, as opposed to me running around with the old blokes from Adelaide Uni, is the standard less for me because it doesn't really matter and it's not going to affect my livelihood if I can't go and play in the Big Bash League? If the financial consequences are that this person will be banned for life, is the standard higher than they might just miss a match? What if the result of this inquiry is that I might lose my gold medal? Is the standard higher? Does that mean that the lesser lights can be dealt with at a lower standard? What about if my anti-doping rule violation, if it's positive, must mean that everyone in my relay team hands back the gold medal? When you come to work out, have I breached the anti-doping provisions, is the standard higher because there are innocent people about to lose their gold medal? Well, that's a bit of information you didn't have 20 minutes ago. What are you going to do with it? Go back to your sports. Go and have a look at your foundational documents, your constitutions, your bylaws, your members' regulations. Is a standard prescribed? In my working with disciplinary matters at grassroots level, you would be surprised how many times the committee can't find all of the documents? Or who's got a copy of the Constitution? Are we sure this is the current one? I have been involved in matters where members of associations are alleged to have breached the prescribed standards. And the first thing you ask for is, can you give me a copy of the prescribed standards and a copy of the minute of the Board of Management or the committee which resolved that these were the prescribed standards? Well, we haven't got a set of prescribed standards, but your client breached them. So go back and look at your documents. Is there an internal inconsistency? In the interest of protecting the innocent, can I tell you there is a national sporting organisation that has a myriad of different standards of proof within their various codes of behaviour and conduct and racial vilification codes, etc. And that's just the product of them being drafted by different people at different times. Sometimes people put in the phrase comfortable satisfaction. Sometimes they put in the phrase comfortable satisfaction and define it. What often happens with state and lower in the sense of being down the hierarchical line, not less important, is that they simply go to the website of the organisation upstream and cut and paste the documents, and suddenly discover that that is inconsistent with their other foundational documents. You might be in a sport where you actually don't have the ability to be out of the box and come up with your own definition. You might be locked into having to use comfortable satisfaction. But if you've got the choice, what are you going to do? Are you going to call it the balance? Are you going to call it comfortable satisfaction but not define it as greater and less? That's the problem. I personally would be relaxed, I'd be comfortable, if organisations said this shall be, the standard of proof shall be comfortable satisfaction. Because I think that the lawyers who sit on those panels would go back to Brigginshaw and say, well, that's effectively shorthand for Brigginshaw. It's not a separate standard, it's talking about a process. The next thing you should appreciate is there's a difference between these different standards. There's a difference between the balance, comfortable satisfaction, beyond doubt. And for those of you who are working with athletes, I think you ought to be aware that some of these safeguards are a bit illusionary in the way that I've hopefully been able to describe in these few short minutes. Now, the balance of the slides are extracts from cases that, if you're interested, you can go and have a look at. And then part B are the criminal law cases. But we've heard from Western Australian football. Can I leave you in a minute with a slide of what you should never do if you're a judge running a criminal trial, trying to explain to a jury what beyond reasonable doubt is. So the next slide I'm going to put up is what the jury were told by the judge. I don't know who the judge was. It's a Western Australian case. I have the image that it's late November, the WACA test is underway, the judge really wants to be at the test match, the trial's run longer than anyone thought, and he or she thinks, I'm just going to explain to the jury what it means. And you won't be surprised that the Court of Appeal said a criminal trial was much more important than working out whether someone was out LBW, and said that you shouldn't be doing that. So I hope that that's a bit of information you didn't have, and take it back, because check out your foundational documents. Comfortable satisfaction isn't the great safeguard that many people think it is. They want lunch.
So obviously with the doping stuff, the consequences can be fairly serious. Would you be more comfortable, as you said, if comfortable satisfaction could include those two established standards comfortable satisfaction could slide all the way beyond reasonable doubt? Yeah,
what Anthony Crocker thinks about it's not going to make a scrap of difference, because comfortable satisfaction, or not even what Keith Binney thinks about it, comfortable satisfaction is just locked in to WADA and antidote. There is nothing that can be done about it. Comfortable satisfaction is defined in that way and it will not change. Sure. And I am sure that when that developed, people thought they were giving athletes great protection, that the more serious the allegation, this person is a cheat, very profound allegation, much more than beyond reason on the balance, so we're going to get it all the way up, but we're never going to get it there. It won't change within the world of anti-doping, and I guess the message that I would say to those who have some responsibility to what foundational documents look like, you might want to just call it comfortable satisfaction if you're going to use that term, and don't define it, because I work in an area where if I was hearing a matter and I was told the balance was comfortable satisfaction and it was not defined at the front of the bylaws, I would say that is shorthand for the Briginshaw process. But in terms of WADA and the anti-doping world, it's never going to change. Keith's nodding, so he must be right. Yeah, it's not going to change. Yes, Keith?
Yeah, I'm actually interested in, are there any Australian sports that actually have beyond reasonable doubt written into their rules?
Because I come from sports that, in New Zealand anyway, where all of the language, other than basically WADA, is balanced on balance.
Yeah.
So I could argue that actually it is a strong bill.
You could argue
that putting in comfortable satisfaction
is stronger. Yeah.
Does advantage in a New Zealand context.
No, I don't know of any sports in Australia that expressly say that, but there is an example from the world of cricket. Can you remember about 6 or 7 years ago, Pakistan played England, Amir, Butt, and there was one other fellow got caught for spot fixing, and there were criminal trials and they all got criminal sentences, and I think the young Mohammed Amir actually went to jail for, I think a couple of them might have. The ICC, while the criminal investigation was underway, conducted their own inquiry. A bloke called Michael Beloff QC, who's a leading court of arbitration for sport person and a leading sports lawyer, chaired the panel. And they had to turn their mind to what would the standard of proof be, and they determined it would be beyond reasonable doubt because of the serious nature of the allegation, that it was effectively an allegation of criminal behaviour against a background that there was a police investigation which ultimately led to charges and ultimately led to pleas of guilty and subsequently convictions. So that's an example from the cricket world where beyond reasonable doubt has been used. My concern with it being defined as less is that you can never ask yourself, is it a reasonable possibility that this urine sample has in fact been contaminated? Now that's a classic criminal law jury question. If it is a reasonable possibility, then the Crown have not proved their case. So even though the bylaw may not say the standard is beyond reasonable doubt, I think there's work to do, and my concern is that once you define it as less than beyond reasonable doubt, it seems to me you automatically say those traditional safeguards just aren't in the game anymore.
So you were saying just before that if there's not actually enough evidence, even like if they don't think the defence is strong enough, they still have to acquit them. Is that right?
Back to the safeguards.
Yeah. So there's
So they're the sort of things that a jury would be told, or a judge would have to direct him or herself if they were hearing it alone.
But then just in terms of that, if someone actually was acquitted, doesn't WADA then have the capacity to appeal that?
Oh yes, there's capacity to go all the way up to the Court of Arbitration for Sport. But the point I'm making is these questions are the questions that you would ask yourself if you were determining whether something had been proved beyond reasonable doubt. If you're working with a standard of proof that has expressly been defined as less than beyond reasonable doubt, you come along the continuum but you never get to the last station, I think you don't ask these questions, because these are the questions that you ask when you're dealing with beyond reasonable doubt. And it seems to me that if the standard of proof is expressly defined as less than beyond reasonable doubt, there's a pretty good argument that you never get to ask yourself these. You just say, am I comfortably satisfied, having regard to the seriousness of the allegation? And the cricket example shows that in some instances a sporting tribunal is going to say these allegations are so serious you're going to have to prove them beyond doubt. But when you're dealing with comfortable satisfaction when it has been defined, you never do that. You never get to that.
All right, please join me.
One more question. Sorry. Anthony, thanks for your presentation. We work for government and we deal with grassroots sports clubs on a daily basis, and regularly we get questions about tribunals, and more often than not it's volunteer people, mums and dads and whatnot, that are on committees and they have to run the tribunals as well. But like you said, you know, by and large most of them don't have that documentation on hand and how to govern it and things like that. So can you recommend, or is there anything really generic that advice that we can give to those clubs into what to refer to and how to...
Yeah, so mums and dads sit on the disciplinary tribunal.
Absolutely, yeah.
Yeah, stop that.
Yeah.
Go and
Unless the mum or dad's a lawyer.
Yeah.
go and find a group of interested lawyers who are prepared to volunteer their time.
There'll be a lot of lawyers running around in grassroots tribunals.
Well, for 20 years I've done the South Australian Cricket Association grade cricket. It's voluntary, and the commissioners are always lawyers and they volunteer their time.
Yeah.
From the moment of charge to publishing the reasons takes between 8 to 9 hours. And sports rely on volunteers. You know, I'm not telling anyone anything new, but you've got to have lawyers doing it. In South Australia, the guys, the two Damians from Adelaide will be able to speak about it this afternoon. The Department of Sport in South Australia has a sport dispute resolution section where an organisation could phone up and say, we've got a problem with a member, we want to prosecute the member for breaching prescribed standards or something. Can you put a panel together? So there are a group of lawyers who will say, yes, I'll chair that panel, and the department gets 2 other people who are not lawyers but are experienced sport administrators. You don't have anything like that?
Well, I mean, often the experienced sport administrators are on the panel, but they're not lawyers.
Yeah.
So the decisions are often not made on knowledge of legal.
Yeah, and when you're sort of dealing with different standards of proof, it's just you're placing an impossible burden on these people, particularly if they're members of the organisation who then have to confront the person in the car park next week and
Just one more quick comment. Anthony, there's a list on ANZLA website.
yeah.
Australian New Zealand Sports Association, there's a list of lawyers on it.
Yeah.
Who will volunteer.
That's good. Does everyone know what ANZLA is? ANZSLA, Australian New Zealand Sports Law Association. There's a number of members who are present here, and that's right, Rebecca, that if you go onto their, there's public and a members only area, but the public area lists lawyers in each of the Australian jurisdictions who are prepared to make themselves available to assist in sporting disputes. ANZSLA, ANZLA. They have a national conference, the next one's in October in Sydney.